Canadian suffrage groups have looked to legal reform as a means to change women's circumstances. Their fight for stronger legal measures against sexual discrimination and inequality ultimately led to the inclusion of sex as a protected ground within Section 15 of the Canadian Charter of Rights and Freedoms. Has Section 15 lived up to the hopes that it will become a tool for equality? Is there still some work to be done?
Well, I think Section 15 certainly has become a tool for equality rights in Canada, no question. Is there still work to be done? Absolutely. And just by way of some history, I think it's important to know that it really wasn't sex as a ground that women were fighting for in the early 80s when they were talking about an equality provision in the Charter of Rights and Freedoms. That sex as a ground was already in the Canadian Bill of Rights, and that came in 1960. So it was there. But the problem with the Bill of Rights was that it didn't allow the courts to really interpret equality rights in a substantive way. So the cases that were taken before the courts in the 60s, 70s, based on the Canadian Bill of Rights, were by and large unsuccessful for women who brought them on the basis of sex discrimination. And the most famous case there is the Bliss case, which involved a woman who was pregnant. She was arguing that she hadn't received insurance benefits, and the court basically said, you're being treated just like every other pregnant woman, and therefore there is no discrimination. So the test that the court used was what we call a similarly situated test. It treated likes alike. And so in the 80s, when there was talk of a Charter of Rights and Freedoms, women decided to get together and argue that there needed to be stronger provisions written into a section that was going to be an equality rights provision. And so actually Doris Anderson, who was the president of the Status of Women Canada, organized a conference. And the government, believe it or not, canceled the conference. And so women across the country mobilized, and about 1,300 of them came together in Ottawa to talk about what needed to be put into this new charter. Two major outcomes flowed from that conference. One was the addition of what has become Section 28 of the Charter, and that was ensuring that all the rights and freedoms in the Charter would be guaranteed equally to male and female persons. So that was very important. Secondly, they wanted to ensure that the wording of Section 15 was going to be more than what had been in the Bill of Rights, because what was being proposed for an equality rights provision in the Charter was essentially a rewording of what was in the Bill of Rights, and that had not been successful. So what they insisted be added are provisions that would guarantee the equal benefit of the law, which meant that you couldn't just look at whether or not a particular provision or law or policy that the government had enacted was going to be, that the women were going to be treated equally within their group, but rather you were going to look at the impact of that particular provision on that group of women or on that individual woman. So that was very, very important. So the conference really, really made a difference to what in the end became the wording of Section 15. And your question, has it lived up to its hopes, Section 15? I would say there's certainly been a lot of progress over the years with respect to equality rights in Canada. Right beginning with the very first case, the Andrews case in 1989, the court made a change. It decided that it would leave the similarly situated test behind, and it adopted what we now call a substantive equality analysis, which is really looking at the impact of a particular law or provision on the group, the vulnerable group, the group of disadvantaged persons, etc. So that was very, very important, and there have been many gains made using Section 15 as a tool, as you put it. Maternity benefits, recognition of discrimination on the basis of pregnancy as sex discrimination, pay equity, laws around sexual assault, what constitutes consent, whether or not a sexual assault complainant's prior sexual history can be used in a trial, sexual harassment in the workplace, on and on, many, many gains. Is there still work to do? Well, yes, I would say there's probably a great deal of work to do. There have been quite a few critiques over the years as to how Section 15 is interpreted by the courts. And the courts, I would say, have worked hard to come up with a test that will be applicable in many different situations, because there are many different kinds of cases that are brought to the courts using Section 15. But the test has been critiqued over the years. It started with the Andrews test, which is a fairly straightforward test. Then we saw a number of different variations, nuanced interpretations of the test over the 90s. We had a different test which involved the use of whether or not complainants' dignity interests were affected in the law test. Then there was the CAB test, then there was the Widler test. What we're seeing now is the courts appear to be avoiding Section 15 where they can, and there are critiques largely by legal academics around the fact that the court is not really focused on an adverse impacts analysis when it comes to its determination as to what is considered discrimination. And there are also issues that continue to need to come before the courts. We're still seeing issues around sexual assault, abortion rights, etc. Lastly, I should mention too that taking a case to the courts on a Section 15 claim is a very expensive endeavor, and the government saw fit early on to form a court challenges program. It was canceled. It's been canceled twice, and the current government is looking at reinstating it. But I think that it's an extremely important thing to ensure that if you're going to have a Charter of Rights and Freedoms, that people can access the rights and freedoms that you've got in the Charter, and therefore something like a court challenges program which allows people to access funds to bring their cases to court is extremely important.
You are a former National Board Chair for LEAF, the Women's Legal Education and Action Fund. Could you describe the role that LEAF plays in helping women achieve equality in the courts?
Well, LEAF is an interesting organization. It's probably one of the only women's groups left standing in the country right now, actually. And it was formed before Section 15 came into force and effect, specifically for the purpose of monitoring how the section was going to be interpreted by the courts and assisting the courts with their interpretation. Again, it was just that time in our history when women simply weren't going to take a chance that they weren't going to achieve substantive equality in the courts. And so the purpose of LEAF, when it was formed, and it was formed April 19th, 1985, which is 2 days after Section 15 came into force and effect, was specifically for the purpose of monitoring the development and the interpretation of Section 15 in the courts. And right off the bat, 2 cases were launched that very day, April 19th. So women were very, very ready. And LEAF's been instrumental all the way along since Section 15 came into force and effect with its interpretation. Every major case involving Section 15, I would say, LEAF has been at the table as an intervener, which is it presents arguments to the court on behalf of women, and also not only on behalf of women. Some of the cases LEAF has become involved in haven't involved women at all. They've involved equality rights more generally. For example, the first case, the Andrews case, that went to the Supreme Court of Canada in 1989 involved a male lawyer in BC. LEAF was involved in the Keekster case here in Alberta, involving hate speech. And the reason that LEAF gets involved in those cases is to ensure, again, that Section 15 is being interpreted by the courts in a way that promotes substantive equality. So it always wants to be at the table because, of course, that is in the end going to affect the equality rights of women. So I would say LEAF has been involved in over 90 cases before the courts. It is an amazing group of women who work on these cases from right across the country. And I think one of the reasons that it continues to be the strong organization that it is first of all, because the founding mothers of LEAF had an amazing vision for the organization, and those women are still there, by and large, still working, still monitoring, still watching, and a huge number of women from across the country continue to provide support for the work of LEAF. So I think it's been a very, very successful organization and continues to be so.
When adjudicating cases involving Section 15 of the Charter, has women's legal activism extended to the judicial bench, Specifically, do you consider that female judges bring another perspective to deliberations involving female claimants?
Well, I think that any time you get a diversity of people on a bench, you are going to get some diversity of perspective. I mean, judges are tasked with interpreting the law, obviously, but I don't think they can help but bring their own life history and perspectives to some of their judgments. And that's exactly why we need diversity on the bench. So, do women make a difference? I would say absolutely, and it's very important that they be there. And there are a number of examples where the dissent, for example, has been primarily the women on the bench. And the case that's coming to mind is a human rights case, the Zurich insurance case, where Madam Justice McLaughlin, who was not the Chief Justice at that point, and Madam Justice LaRue de Bay were the only dissenters in the case. They were the only women on the court at that time. And it involved the higher payments that young male drivers under 25 were having to make for insurance. And the court, the majority of the court, the males on the bench, ruled against the males, saying that it was clear that they were actually more dangerous drivers than the females. So they thought it was very legitimate that they should be charged more for insurance. But Madam Justice McLaughlin and Madam Justice LaRue de Bay dissented essentially based on the fact that there wasn't any hard evidence before the court to make that determination. So they'd really based some of their decision on assumptions. And of course the reason, if you think long term, as to why they would be dissenting is because if you think about the assumptions that might be made about women in cases based on myths or stereotypes, that would be very, very dangerous going forward, to have a bench making determinations without hard evidence. And so that's just one example. There are many of where a bench involving women makes a difference.